someone who needs absolutely no introduction to facilitate the session, Advocate Mkhwebane. Thank you.
Thank you so much, Professor Brian MacArthur, for such a very warm welcome. And we appreciate so much if you can pass our appreciation to the VC, to the Council of the University for availing this platform, for embracing Africa. I mean, you need to also inform them the university is playing a very critical role in Africa as well, for capacity building, for us achieving the aspirations of the African Union for Agenda 2063. So you must know that you play a very critical role. But then thank you so much to Professor Madonsela, who also does not need any introduction, a phenomenal advocate, a professor, a social justice advocate, so who has kindly agreed to facilitate this report writing skills webinar, and which we need the most, and all our officers or as ombudsmen, we need it. And our staff needs to be trained on it, and even the fellow ombudsman, so that we can be able to do our work and our constitutional mandates as various ombudsmen. So I will then make sure that I facilitate this session as briefly and succinctly as possible. This is your webinar. I'll give you a lot of time to ask questions, clarifications. I only see the Ombudsman or the Western Cape office, which has joined us. I think is the Ombudsman, the Police Ombudsman. For now, I will keep on acknowledging each and everyone who's joining us, especially the Ombudsman who are joining us, and we appreciate that they've allowed their staff to join us. So I think without any waste of time, also acknowledge Shakila, acknowledge Frankie and Marion. Thank you so much for facilitating this, such a great job. So I will then facilitate anyone who has a question, a clarification. There is a chat box where you can then type your question to the panelists or to everyone to see. And further, you can raise your hand. I don't know whether we've opened up for them to also ask questions through voice note. I think that I will clarify with Marion and Frankie. But then if not, so use the chat box to ask your questions and clarifications. There's a Q&A, there's also a chat. Thank you so much. I think we have around 415 participants so far, and I think it's a sizable number for us to start immediately, because we have Professor Madonsela, Professor MacArthur, they have other commitments, and we don't want to take a lot of their time. So over to you, Professor Madonsela, as we are privileged to have you in our midst. Thank you.
Thank you, dear colleague, and thank you to all members of AOC and UKZN who have made this privilege possible. I am overjoyed to reconnect with the Ombudsman family and with AOC. AOC is like a baby to me, and it's actually 10 years old at the stage, going for 11. And when you see your baby, or a baby created by you and others, continue to do what it was born to do, pursuing its purpose and mission, it is heartwarming, and therefore it is a privilege to see AOC doing this. I particularly am happy that we're talking about report writing, because often a very good investigation gets sabotaged by the fact that the report does not hit the right spot. That brings me to something that happened to me yesterday. Yesterday, I invited my son to join me to watch a series that is called Anchored in Law. And the senior advocate there is interviewing members of the judiciary about various interesting judgments, perspectives, and even just who are they as human beings. So we watched quite a number of episodes of it. And at the end of it, I asked my son, "Did you like that?" I expected him to say it was riveting because I had found it riveting. I expected him to say it was insightful because I found it insightful. And I expected him to say that it was illuminating how the legal system works and how the people in that system think. He said none. He said, "Oh, it was very good, but," and he quickly said, "but it is only good for lawyers." And I can tell that it was only meant for lawyers, judges, and academics. And I understood it because I understand the law, but if I were to refer it to some of my friends, I don't think they're going to understand half the things that we said. And because they won't understand it, then they might not really continue to watch it. The same thing appears to affect our reports. It depends on how the message is received on the other side and not how we want it to be received. Ultimately, once you have written a report, it's not yours. It is for the world, and the world will do with your report as it pleases. And the complexity we have is we're writing for multiple audiences. Or my son, to make his point quickly, decided to show me a series on how to communicate. And in this series, how to communicate hard concepts. In this series, the same guy explains to a child and then sits with a teenager, then goes to sit with an undergrad, with a college student, then he sits with an undergrad, then he sits with a graduate, and finally with an expert. And in all of these different scenarios, the way he communicates is different. As ombudsman, you don't have the same luxury. As investigators who conduct administrative investigations, we don't have that luxury of being able to speak to a child differently and speaking to a teenager, an undergrad, a grad, and an expert. In one report, you have to communicate to everyone. And which brings me to what is a report? What is an ombudsman report? You already know that question. So that's preaching to the choir. The way I have seen an ombudsman report throughout my life and an administrative report, which I do now outside of the ombudsman sphere, is it is your communication of a fact-finding mission, your analysis of the facts, and your conclusions and remedies. Whether you are suggesting them as in recommendations or you are ordering them as in the possibility that the Public Protector South Africa and others have. They can recommend if they want, or they can order if they do. And your report is your only narrative to tell them what were you investigating, what were your findings, and what should they do with those investigations. So what is a good investigative report? During my time as the Public Protector South Africa, I attended several investigative processes. One of them was sharpening your teeth. And if you haven't attended Sharpening Your Teeth, I would say do attend it. It's very good in getting you to understand the relationship between your report and your investigation. So what is a good investigation report? It's a report that communicates clearly what was investigated, how it was investigated, what were the findings, and how should the problem be solved if a problem was found. But what does it take to have a good investigation? I mean, what does it take to have a good investigative report? It takes a good investigation and the art of communicating. A good investigation process and the art of communicating. So those two together. Let's start with a good investigation. What would it have? A good investigation is going to have 3 elements. It must have rigor, which the depth of the investigation should be of high quality. It must have promptitude, which is it must be done timeously so that your case is still cold. Your trail is still hot, not cold. And you're able to find those documents before they're shredded. You're able to mine people's memories whilst they're still fresh. And you're able to tell the story whilst people are still interested. And that's the importance of promptitude. And lastly, it must be ethical. Hence, the acronym for a good report is RIPE. For those of you who are South African, the best case to look at in terms of the elements of a good investigation is the case of Public Protector versus Mail and Guardian. It concerned the investigation of the Public Protector to the way government had procured oil. In the end, the money was stolen and no oil was delivered, and government ended up having to pay twice for the oil. This was the Petro SA case. And when the Public Protector issued a report of no wrongdoing or a closing report of some sort, the Mail and Guardian took this matter to court. And the court said it is extremely important that as a Public Protector or as an ombudsman, you use all of your powers. Unlike judges, ombudsmen need not be stationary. They need not wait for everything that's going to be brought to you by others. You have the power to dig. You can't say, oh, the complainant did not give me this document, did not say this, did not provide me witnesses. You have this unusual power to find the documents on your own, to find witnesses beyond the complainant on your own, to find the law on your own. And the Mail and Guardian case said that. It also said that it's important that you remain with an open mind. You begin with an open mind and you remain with an open mind. So investigations should show that you had an open mind throughout the process. You didn't prejudge the conclusions, and you listened to everyone and then you evaluated. And then I'm going to talk to what the report is going to say about that. So firstly, a good report will be anchored in a good investigation, and a good investigation is one that is ripe, which is rigorous, prompt, and ethical. Now let's get into how do you get your investigation to be ripe? There are 5 stages of an investigation that you really need to manage properly. The first one is how you manage the reception of your case, whether it is a complaint or a concern. I distinguish between a complaint and a concern because a complaint is when somebody approaches your office. A concern is when you yourself read a newspaper or you hear about something and you do an own investigation. The second step is the planning of an investigation. After receiving a complaint and triaging your complaint, which is determining, is this within my remit? And if it's within my remit, should I do it or can somebody do it better? And I see in the room that we've got various kinds of ombudsmen. So a matter could land with the perpetrator when it could be better dealt with by a police ombudsman, or it could be dealt better with by the Judicial Inspectorate of Prisons or the Inspector General of Intelligence, and etc., etc. So you have to think very carefully, even if it's within my remit, is my office the best office to deal with this, or could a sister institution or brother institution, whichever gender you want to use, do this thing better? And in the triaging, in your own units, you'd have to decide. And the perpetrator, for example, with various units, would then determine it should go to early resolution if it's a life and death matter or a bread and butter issue. It had to go through early resolution or service delivery, because usually people have different skills between service delivery and conduct failure. So if it's conduct failure, it goes to the right person. Then you have to do the investigation planning. Dear colleagues, your planning map is extremely important, because if you don't plan, you're going to go to and fro, and you're going to be given a runaround by your colleagues. Then the investigation, then report, and aftercare, which is how you manage the media, how you manage the stakeholders. So a good investigation is going to give you a good grounding for your report. Now, let's now get into the investigation itself, into the report writing itself. I've said it needs to be based on a right report. The report writing itself is a storytelling. It depends on the art of storytelling. You have to ask yourself, when they've read this report, how do you want them to think? So it has to reach them cognitively. How do you want them to feel? It has to tug at their emotions. How do you want them to judge this matter? It has to tug at their morality. And lastly, how do you want them to act? For all of these things, if it doesn't hit them emotionally or cognitively, they're likely to act in a manner that you don't want them to act, because this is your message to them. This is, you are asking them to believe that you have found the truth the best way possible. And what you're telling is the truth as you know it. And you do know that when we receive a complaint or a concern, at the end of the day, there are various versions of the truth. And I remember when we were trained at, and in the UK, there's an organization there, PI, it's called Public Administration International, and PIs would say that there is the complainant's truth, version of the truth, there's the respondent's version of the truth, and there's the real truth. So you, as an ombudsman, are now giving us the real truth, which is going to have fragments of what everyone has told you. But it's not suggesting that the others were lying. It's just saying they were telling you what they thought you needed to know, and sometimes what they themselves knew. And so we don't have to be presumptuous about whether they were telling the truth or not. And that's where you go with the Mail and Guardian case, which says you have, as an ombudsman, show that you have kept a healthy level of skepticism. And that's not cynicism. Cynicism is when you don't believe people and you dismiss it, but a healthy level of skepticism. So the report itself, it has to be clear, concise, accurate, professional, and persuasive. This is the methodology we arrived at during my days as a perpetrator. By just looking at various judgments and looking at various reports, we concluded that at the end of the day, the kinds of reports that have the impact that the author of the report wants are reports that are clear. They're concise in the way ideas are formulated and concepts are communicated. It's accurate in the way it communicates facts, it communicates law, and it communicates the logical processes through which these decisions have been arrived at. It has to be professional. Avoid emotive language. Avoid something that may come across as insults. And I do know that when it comes to lawyers, traditional lawyering is always about making the other party feel as small as possible and as wrong as possible. I learned as an ombudsman, and now when I do other reports, that a report need not make the other party feel bad. Actually, by making them feel that ordinarily they're a good person, but they drop the ball here, you're more likely to get them to accept your reasoning and to do the right thing. But here I'm talking about an administrative report that relates to service failure. It's more difficult, of course, when you're dealing with reports, dealing with corruption, fraud, or theft. So the last thing is that it has to be persuasive. Persuasive is the part that I spoke about, that it has to hit them at cognitive level, at emotional level, moral level, and it must have the impact of them believing that this is not about this person not liking me. This is about the person digging into what happened and contrasting that with what should have happened in terms of applicable principles, whether they are law or ethical standards, etc., and concluding as logically as possible. So I have said that the report has to be clear, concise, accurate, professional, and persuasive. How do you present it? This is my last bit. How does the report, a good report, flow? Well, firstly, the report should tell you what is the issue. Then it should tell whoever's reading this report, what rule or principles are you going to use to resolve this issue? It must give them a very clear outline of your analysis. How did you analyze the issues? And lastly, what are your conclusions? Again, what we learned from the Ombudsman of the UK was a very simple approach to investigative reports that says you just start with telling them what happened. This is a factual analysis. What happened? What should have happened, which is what does the law, what do principles say about what happened? And then the third part is there discrepancy between what happened and what should have happened? And if there is a discrepancy, is it explainable and justifiable? So we don't simply say just because there's a discrepancy, then it is improper conduct or wrongful conduct. When there's a discrepancy, we then ask whether there's a justification, a reasonable justification for the discrepancy. And if there isn't, we then say, shall we call this wrongful conduct? And there's different terminology for it. In South Africa, you can call it maladministration under the Public Protector Act, or improper conduct under the Constitution. In other agencies, you might just call it irregular conduct or unjust conduct. So once you've called it, you then have to ask yourself, was somebody prejudiced, or did somebody suffer an injustice because of this conduct? And that somebody could be one person or could be a group of people, like the whole nation. And so a person, the municipality, well, maybe let me just give you a simple case that we dealt with Facilitator. A municipality dug next to somebody's house, and in digging next to somebody's house, there was a sinkhole, and the house fell through the sinkhole. and he had no house. The house collapsed. And then the municipality's argument was that the sinkhole was not caused by them. But when we looked at it, we then said, what should have happened? They should have made this fellow aware of what they were going to do. They should have administratively given clear instructions to their people on what to do and what not to do. And they didn't do any of that. And in the end, somebody's house collapsed. And then we then said, the last question is, if somebody was prejudiced, how do you place them as close as possible to where they would have been but for the improper conduct? And this applies whether we're dealing with service failure or corruption or fraud or theft. We have to ask, how do we restore balance? And that's the last part of your report, is the remedies. And of course, it depends on the circumstances. In the Power Protector South Africa, the remedies might be directional or they might be recommendatory. And you recommend, how do they fix it? How do they place the people or the person as close as possible to where they would have been but for the injustice? I'm ready to take questions from you. I was going to do this presentation with slides, then we got load shedded. I'm happy to send you the slides after this presentation in the next coming days. Right. Thank you, dear colleagues. That is all for now. Questions?
Wow, thank you so much, Advocate. This is so informative. And you know, even myself, I get a lot of information. So it's true that we learn until we die in life. So it's very informative. And there are questions which I will read for you. The first one, well, it's about the slides, why were we not provided the slides for the training. I think Marion and Frankie, you can email the presentation, because I think there is a presentation. I don't know whether, Professor, you've shared it with Frankie and Marion, but then they can start sharing that in the meantime. And it was also going to be very helpful if the host was also just showing some slides of your presentation. So, and then there is a question from Advocate Dinky Dube from the Military Ombudsman in South Africa, who was asking about the quality assurance mechanisms for an ombudsman to adopt in order to make the investigation report to withstand scrutiny. That's another question. And there is another one from the Nigeria Ombudsman in Port Harcourt. I want to know who is referred to as an ombudsman police. I think possibly they don't have the ombudsman police in Nigeria, but Professor, you'll explain. And then how long does it take the ombudsman to make a decision? There's Mlekedi Shandu. I think some of the participants might be students who would want to or who are interested in the ombudsmanship and report writing, which is helpful because what you said, Professor, applies across the board. Whether you are an investigator in the police, you are an investigator in DPCI, NPA, this information is very critical. So the time frame for the training should be extended. Participants should voice their questions. This is from the Public Complaints Commission in Nigeria. And what does it take to present a good investigative report? I think Professor dealt with that, but I think you will just summarize that. Why are there 0 to very few bursaries? Okay, for students, this one, it's a question for VC and Professor McCarthy. because they want to study law, or, well, there's few bursaries for people who want to study law. So I think those are the questions which are relating to this particular training or the presentation of the professor. Over to you, Professor.
Thank you, Public Protector, and thank you, colleagues. Regarding the presentation, I apologize, I didn't send it to Frankie, and the person who suggested that I should have sent it is right. It works better that way because you never know what's going to happen in life in times of COVID or generally, because if that had happened, I could have then asked them to show it from their side. It's been a very long and difficult week. I accepted this in knowing that my program this week is full, and therefore I was only able to finalize the presentation quite late, although the principles themselves are part of an investigations course I used to present at the Public Protector. I had created one. They're also part of a standard operating protocol that I drafted and had the team review and reach whilst I was Public Protector. And I would ask the Public Protector if they still do have that standard operating protocol for administrative investigations to share it with you. It's also going to be helpful together with the slides. And we will definitely make sure that you get the slides shortly after this investigation. To the question by Ms. Dube around the quality assurance process, that's extremely important. I would say it starts with appointing people with the right skills, knowledge, and attitudes. That enhances the quality of investigations and reports you're going to get. And the second part is having a standard operating protocol that tells everyone how the investigation should be conducted and what the structure of a report should look like. In the standard operating protocol for the Public Protector, for example, we had included a section that gives you the headings for the structure of the report, because if you are one institution, you would want the structure of the report to be the same, regardless of who prepared it. Then you need a quality assurance, a last port of call, which would obviously be the head of the institution. But I must say that you mustn't rely too much on your quality assurance final protocol, because the problem with that is that you then get with a bottleneck. When reports come half-baked and everything has to be almost redone at quality assurance, that then undermines promptitude. You need a peer review mechanism at every level, and therefore, instead of just only having a final quality assuring authority in your institution, which you must have a final quality assuring institution, but at every level of your institution, have a peer review mechanism. Even if there's two people in a unit, even judges, they have a peer review. A judge doesn't just write a judgment and then go to deliver. They, at the Concord, they sit there and everyone talks about what their thoughts are and why they're thinking that way. What's their authority for thinking that way? At high courts, they do that. Law firms, they do the same thing. You come up with something and then there's a tea party arranged with your colleagues where they can deal with these matters. Of course, if it's a highly contested matter and there are security issues, you would restrict the number of people that will go into that quality assurance. I hope that answers your question, Dinky. And being a military ombud, you would know that some of these things then cannot go into a very big quality assurance process. Again, there it's balancing between rigor and promptitude and ethics, those three. If you say your investigation has to be ripe, rigor is as important as promptitude, and promptitude is as important as ethics, and ethics might relate to making sure that, for example, if there are whistleblowers under the Protected Disclosures Act in South Africa or the Open Democracy Act in other countries, those whistleblowers do not find their names being disclosed because the loop was too wide in terms of who had sight of the information in the report. What are the qualities of a good report? As I indicated, is that it's a report that is kept, that is clear, concise, accurate, professional, and persuasive. In terms of the structure, there's a training in universities on research and writing. In other places, they call it IRAC. In other places, they call it FIRAC. In other places, they call it IPEC. What is the issue? What principles are you going to use to determine the answers? What's your analysis? Take us into your logical thought process. And lastly, what are your conclusions? At the level of public protector reports, normally you would start with what is the complaint and what are the parties? I personally, as part of persuasiveness, used to also include a bit there about the complainant. I said to you, your report should talk to people cognitively and emotionally. If your complainant is a wooden caricature, the person who's reading the report doesn't have empathy with the complainant. So make your complainant real in the same way as, for example, mediation. In the public protector, these things used to be resolved telephonically or in writing before my time. And then I introduced physical mediation where people were in the room. Why I did that was because you get touched when you see this person who's been harmed. And I saw people change there because people are essentially good human beings, and not many people really wake up in the morning and say, I'm going to harm Gogo Dlamini. They don't. So in the report, you don't have that luxury of having Gogo Dlamini in the room telling about how this injustice affected her life. But in the report, you can make your complainant come alive. And again, Dinky, talking about the military ombud, we had one case where this guy lost his house, literally, because the pension money that had been promised was not paid on time, and a bank foreclosed on him. And we had to make a determination about if government had done its job the way it's supposed to, would this complainant have lost his house? So this whole story about what happened, what should have happened, is there a discrepancy? And if there's a discrepancy, did somebody suffer harm or injustice or prejudice? And if so, what are we going to do about it? We concluded that if government had just done what they were supposed to do, the harm would not have been suffered. There's another case which eventually went to the Pretoria High Court. And this was a matter between the NEF and us, and the complainant. Again, my view was that this person suffered harm. And we presented this person as, who is this person? She's a small business person with limited means in an environment where it's difficult for being a woman from a historically disadvantaged background to earn loans, to be trusted by the market. And therefore, if you are treated badly, it's going to be a double blow. And well, certainly, although I thought it was persuasive, I thought it was kept, it didn't really persuade the NEF, and it hasn't persuaded the Pretoria Court. Which brings me to one last thing. When you write your report, dear colleagues, you must decide, who are you writing it for? And it's quite amazing the different answers you get to this question. There are those who are saying, we're writing it for the judges because they're going to review us. There are those who are saying, I'm writing to the complainant because they're the ones who got the complaint. I personally think the key person that you're writing the report to is the person you expect to implement the remedies. And the next key person or equally key person you are writing the report to is the person who's losing in this report, the one you are deciding against. They need to be persuaded that you did the right thing. So the structure, if you look at the Public Protector report, you know, you have it, it's the complaint, it is your authority, because you have to indicate your authority, and there you can also deal with the preliminary issues around why this matter didn't go to someone else, why did you investigate it given the fact that it is an old issue, etc. And then you go to the issues, you tell them, what are the issues? There's a difference between issues and the complaint, is that in the complaint, what's the essence of the injustice that they claim was suffered? So sometimes the complaint and the issues are the same, but usually it takes drilling down to get to the issues. And then you then tell us, what principles did you use to deal with the issues? Then you tell us, how did you find the facts? On your investigation, the investigation part has two components. It has the process. How did you investigate? What was your process? And then the second part is, what did you uncover? You will uncover information and evidence, and please don't confuse information and evidence, because information is whatever leads you to evidence. For example, an informant might, somebody might give you a document that has not been authenticated, whether it's the correct document or not. It is an authentic document or not. So that's information that allows you to go into the system. A journalist might give you information. You use those as part of your roadmap that leads you to the actual document, which becomes evidence. But people giving you sworn statements, that is evidence, because even in a court of law, that is going to be evidence. So a good report is a report that sets out clearly what the issue is, who are the parties, and what's your authority for dealing with this matter? What issues did you distill for investigation? How did you investigate this matter? What principles, what laws and principles did you apply in determining the discrepancy between what happened and what should have happened? And then indicating what were your findings and what are the remedies. Thank you.
Thank you so much, Prof, for the information and for answering. We still have more questions, but I think there is a presentation which was prepared by AORC, and that presentation also has a lot of information which relates to report writing, but as well what is currently happening within the Public Protector South Africa, because it also addresses the issues you are mentioning, the investigation of issues, the evidence difference, and the issue of what happened, what should have happened, the prescripts, the Section 7(9) notice, and all those. So I think it will also help them. And I think on the quality assurance, there is a process which currently the Public Protector or office is going through, and your advice is also noted, and it will detail how the process can be taken, the quality assurance certificate. And it's true what you're saying, that throughout the process, there must be a quality assurance. Instead of just malicious compliance, an investigator drafting a report and just passing it through without firstly quality assuring it themselves and the supervisor, the next line before it reaches the Public Protector, because basically that's what should be happening and is happening. So there is another question which is critical. The person is asking the issue of emotive or the emotions. How do you, there's a lot of, I think there's the one who said, how long does it take? You've answered, because you at the beginning, you
no, PP, I did not answer that. I think in your standard operating protocol, you have to indicate how long should it take to do certain kinds of investigations. For example, in our case, we distinguish between an early resolution matter, and that matter was supposed to be concluded within a day and at most up to 3 months. And so you can't wait for 3 months, though, if somebody needs an operation at the hospital and they're complaining about a maladministration in assessing their right to be dealt with. Everything will depend on the circumstances. But no investigation, ideally, should take longer than 6 months, regardless of what investigation is it. And I must indicate to you that the reason why you have to keep your investigations prompt is because with every day of not concluding this matter, the case becomes cold. And you know that in criminal investigations, cold cases are the most difficult matters to resolve. As a result, they close them. Once it becomes cold, they close it unless somebody someday, maybe 20 years later, comes back and says, oh, I have evidence that can assist you, because things get shredded. So that's the first problem why you should resolve it fast. But the second reason why you should resolve it fast is remedies. Whether it's an injustice to Gogo Dlamini, her life is at a standstill whilst they're waiting for the remedy. Or it is a matter of corruption, theft, or fraud. If it's a matter of corruption, theft, or fraud, they will be continued to be corrupt, stealing, and being fraudulent. And two, they are going to parcel the money out into safe havens overseas, or launder the money by buying properties and things that you cannot immediately link to this money. So when you finally have your conclusions, it becomes an academic exercise. Also, they stole the money. What about it? Okay, they may go to jail, but when they come back from jail, they'll be rich anyway. So try to conclude it within 6 months. Again, the standard operating protocol that we prepared during my time at the Power Protector gives you some suggestions around timelines or the standards that we decided on each investigation.
Okay, Prof, there's still a lot of questions. I think we will just go through them. And when I was saying you addressed it earlier, when you, in your opening, that people must be quick, possibly the person joined us late, and I think other issues will be handled by the presentation which you are going to share. So the other one is how to avoid emotive language in your report, because I find it difficult to use cold formal language to describe people's pain and suffering. The other one, when administrative injustice happens within the ombudsman, who do we report to? The other one, what is the difference between an ombudsman investigation officer and an ombudsman police? I think this one of an ombudsman police comes back again because you mentioned it earlier. Maybe you'll clarify, Professor, that in South Africa, like I mentioned earlier, we have the Western Cape Police Ombudsman who checks the behavior and the problems people are facing within that space. And in South Africa, we have a lot of sector-specific ombudsman. I think you'll deal with those. And then, okay, the next question is asked to both of us. Does the basic Department of Education in South Africa have an ombudsman? And if so, how does one go about tackling a corruption matter that has not received any attention from the KwaZulu-Natal Department of Basic Education and Corruption Watch? South Africa, as a young lad, has been disadvantaged in a great way by the Department of Basic Education as a result of corruption. I think, Prof, you'll answer that, but I think that falls within the Public Protector mandate. I thought it's a student possibly who's within a university, because some universities, they do have ombudsmen. And Prof, you said good investigation process must have 3 elements. Which one of it is it that it must be ethical? Can that be more explained, the ethical element? This is from Nigeria. And the next one, in Nigeria, we are having a problem when conducting an investigation. I will suggest we have a process whereby whosoever is guilty of a said claim should come to book. I think it's one of the students. How does your own ombudsman enforce compliance for your recommendations, especially with recalcitrant respondents? This is also from Nigeria. And then the next one, if a respondent authority is questioning the authority of the ombudsman to carry out the investigation, at what stage of the process could one reasonably expect the challenge to come? I think when they are taking us to court, I think during your time, Prof, it has happened, also still happening now. What is the African Ombudsman doing in strengthening the Nigerian public? Okay, this is for the Nigerian Public Complaints Commission. I think some of them we will record a note, and then I will pass through to my counterparts, especially who are in AOMA, to respond, and we can put it in AORC website. I had a problem where I drafted an investigation report. I made reference to the law. I reconciled with what had happened. On submitting the report, the manager that reviewed the report gave me an instruction to change the term, saying it is a bit harsh with regard to the recommendations I had made. There was irregular expenditure proven and the PFMA was used. How does one address that with the manager? This one is from the KZN Treasury Forensic Services. So this is well attended, Prof, as I said, that it's beneficial to all sectors. I want to ask, how powerful is the Ombudsman and the Ombudsman Office anyway? I think this one is information we can put on the AORC website. At the time of investigating the investigating process, who should make the decision of whether the remedial actions? Oh, Prof, you've got so many questions. So this thing is moving a lot, but I think some of them will have to make sure that we respond to on our website. There's another one. I do an LLM student at UKZN. I also work at the Judicial Inspectorate for Correctional Services. I've conducted investigation to the death of inmates. Some findings show negligence and excessive use of force by correctional officers. Unfortunately, the culture of impunity at correctional facilities still triumph. The lack of accountability and prosecution is disappointing. How and what can be done to hold correctional officers to account? My comment is whether Ombudsman can be proactive and investigate matters of public interest without a complaint. I think this one you've dealt with it, an own initiative investigation. A request for the session recording, okay. Prof mentioned having an open mind and remain open-minded. I think it's the Mail and Guardian Supreme Court of Appeal judgment. An investigating team who has started with investigation through the interviewing witnesses, doing data analysis up to conclusion. How do you remain open-minded when you have already formed an opinion on the whole matter? So, yeah. What is the best approach for collection of evidence to support a best quality investigative report? From the Health Ombudsman, who's here. From Lesotho, Prof, really your presentation is interesting. Could you please reiterate 5 stages of a good investigation? And we've got, Prof mentioned having an open mind and remain open-minded as you get to the report writing stage. As the investigating team, who has started with the investigation through the interview? Okay, this one repeating. From Nigerian Ombudsman, please confirm, okay, the African Ombudsman Research Officers Certificate courses. This one, Frankie and Tim, I hope you are noting. Prof, what advices can you give to the organizations that are dealing with backlog cases that dates back to 3 years and perhaps still need more information from the respondents? And then, can you please say something about the need for observations and recommendations as part of conclusions? Prof, I hope you are noting all this. What is the role of the team in getting a report to be best? Okay, that one you dealt with. Quality assurance. Again, there's another question on that. We will share the presentation. What role is the African Ombudsman playing in ensuring that institutions and making it a household name, like the police or military? I don't know, what does that mean? Okay, I think, Prof, a lot of the questions which were asked here, Frankie,
hello,
that we record them and we will put the answers on our website. So there is I support Prof McCarthy's response as an official from the Department of Education Limpopo. Biasaries are sector specific, hence the department. I don't know, I think, Prof, I don't know where you mentioned that. Okay, this is noted. We will share the presentations. We have your emails. We've shared the AOMA website on the site. If you check on the Zoom webinar chat, there's a lot of information there. And the police ombudsman, they've posted their website as well. So you can go there. But for now, after hearing Prof as well, that she has a lot to do today, if we can make sure that we give Prof an opportunity again to just address all these issues generally. Some of them we will address with the presentation, or as well sharing what the center has prepared, because there's a well-written presentation also from the center. Over to you, Professor.
thank you, Public Protector, and thank you to the colleagues for their comments and questions. There's so many of them, I don't know where to start. What we will do is look at them later with Frankie and perhaps answer some of them via email. Maybe let me just start with the quick question around how do you de-escalate tension between you and the authority you are investigating? If it's an administrative investigation, it's very important that you de-escalate the tension. And somebody said, how do you communicate an injustice without emotive language? Being professional does not mean it should be wooden and devoid of emotion. You can communicate how the affected people received the impact of the conduct, how their lives are impacted today, and how it really would help them if government or if the party concerned were to change the way they do things. If you look at the report that we wrote that is called, they called it justice. You try to give them something. If there's some things that they did well, the report should say they did this well. For example, at the beginning, they did receive the complaint that there was corruption in the master. The master of the High Court in South Africa is somebody who looks after the monies of orphans. It's a very critical service to society. And Mrs. M reported that there was corruption in the way these monies of orphans were being dispensed. Instead of proceeding with investigating the matter, it was received, but instead she was left to the wolves, and the wolves dealt with her. Eventually she had depression, and because she came to work on and off, eventually she was dismissed for AWOL, but they didn't follow PLA, which is the policy framework in the public service that the employer is supposed to follow. So in the report, we talk about what they did well and how they responded to us. you thank them for the little things that they did well. And in so doing, you are buying rapport between you and the institution that you're dealing with. And then you then deal with where did things go pear-shaped. By then, you have pulled them into your space and involved them at a cerebral level on hello. Hello.
All good.
Yes, hello. Please go
Yeah,
on.
yes.
Okay, fantastic. Something just went wrong there. I was saying it's really, writing a report is an exercise in persuasive communication. You know that you have the truth, but you don't want to just throw the truth at them. You want them to buy into that truth, to opt into your line of thinking and be persuaded that doing what you want them to do is the right thing to do. So yes, you can include what happened, but avoid using things like terrible. And if they behave badly, avoid using words like arrogant. Just use words like they were rude, and you would communicate the same thing. And then there's somebody who asked, what's the difference between a police ombudsman and a normal ombudsman? They're both administrative investigations. However, most ombudsman investigations are not disciplinary proceedings. They're not criminal investigations. They just a sui generis kind of investigation. For example, in most administrative investigations, you can't, on the basis of just your investigation, have somebody fired. And therefore, if you look at, for example, the report we did on against the rules, we didn't ask for anybody to be fired because there's a process that's supposed to be engaged in for disciplinary proceedings in the police force. So we said, these are our findings, then you have to institute disciplinary proceedings based on your own legal processes, and then determine what to do with the person. Even with the firing of ministers, we wouldn't say have them fired, although people think that we had to say, and we said they should be fired. We said consider taking disciplinary action against that person. So yes, you can be persuasive without being emotive. But the greater story you're going to tell that will persuade them, if it's a corruption story, make sure you paint a vivid picture on what this has taken away from the people. If it's maladministration, paint a vivid picture on how those impacted by that maladministration have been impacted and how their lives would have been better or normal if this had not happened. De-escalate tensions. Somebody wanted to know, at what stage do you assert your powers regarding your authority to investigate? Usually that happens when you just start the investigation, and try to deal with it decisively then. When you start the investigation, usually they write back to you and say, you have no authority to investigate us. And that's where it's a point in limine. If it were court proceedings, this would be a point in limine. And you then have to talk to them very politely again about this is the reason you have authority to investigate. They may say that, oh, this is a matter for a court of law, or they may say this matter, if you are a public protector, this matter is older than 2 years. Explain to us what are the compelling reasons you have found to investigate this old matter. Give them those compelling reasons there and then, that these are the matters that we consider, and then adjudicate this matter then. Because your report would then say the respondent institution objected to the jurisdiction of my institution, and this is what they presented as the objection, and this is what I considered as the reason to investigate. And I then did an analysis and concluded that my institution had authority, not only authority, but a duty to investigate this matter. For example, matters that deal with monies, where the state owes someone, surely such a matter should be concluded in favor of the complainant, because no state should benefit at the expense of an ordinary Gogodlamini. Because if the state is raising prescription, it's basically saying, on a technicality, I'm a state that wants to be unjust. Just using a technicality. I owe this Gogodlamini this money, but I refuse to pay. And my ground for refusing to pay him or her is, I am saying it's an old case. No state should be allowed to do that. Because we're not a court, I mean, you as ombudsman, you're not institutions of law. You are institutions of both justice and ethics. Hence, we talk about proper conduct, that what government is supposed to do is ethical. But here we also have the financial services ombudsman and some of the ombudsmen in sectors beyond government. Again, your mandate is not legality only. Your mandate is just capital. If it's the corporate sector, is justice, and justice is not just lawful. It is what is right, what is fair. That's why the Constitutional Court talks about just and equitable. It says it would not be just and equitable to decide in favor of this party. We've considered that it's just and equitable to decide in favor of party B, because that's the constitutional framework in South Africa. But what about the other countries? Nigeria has raised some questions. Again, hold the authority you're dealing with to their own principles. Find something that they have said, or something in their own statute, something in their own policies to hold them to. Because you want them to be persuaded that you're not dreaming up new standards to hold them to. You're using the standards that they have set for themselves to make sure that they comply with those standards. What are ethics? Somebody said, I said the report should be ripe, which is rigorous, prompt. It should comply with principles of rigor, which is thoroughness, which means it's not enough to say, I was given this information by them. Look for the information. If, for example, it's a corruption case, it's not enough to say they didn't give you the information and the complainant didn't. If there are allegations of corruption, the public protector's SOP that I left says, if it's a corruption investigation, it's compulsory for you to do a forensic. It's not a nice to do. It's compulsory for you to do a forensic, which forensic would include ordering their cell phone records, their email records, their bank statements, and possibly going to mine data from their computers. I know that we didn't have that capability at the time I was public protector. It was something that when we went to Singapore, they were shocked that we could conclude a corruption investigation without mining data from people's computers. And that's something that is extremely important if you're talking about rigor. Promptitude, we've discussed, do it as soon as possible. And then the ethical side is your own process should be justifiable. They shouldn't be able to point fingers at Or they shouldn't be able to legitimately point fingers at your own conduct. For example, it's just and ethical to give them an opportunity to respond. As soon as the matter comes up, the person who is accused should be the first person to be told, you are being accused of 1, 2, 3. May I have your comments? You will see, for example, in state capture, they say they were not told, but the president was the very first person the letter was sent to. This person is accusing you, because you don't want to be malicious. You don't want to investigate people behind their backs. So therefore, the first person to know, this is not a criminal investigation. It's an ombudsman investigation. With the police, they can do the investigation before they tell you, and then confront you with information once they have. But with an ombudsman, play open cards. Tell them you've been accused, and that diffuses the tension. It also reduces the possibility of them thinking you out to get them. And of course, if they then don't give you a response, then do your investigation. And once you have some kind of preliminary views, you send it to them. I preferred giving them a provisional report, and many ombudsman offices do that. Unfortunately, when it's high stakes, those preliminary reports tend to be leaked. And when I was pub protector, we then stopped sending them preliminary reports, but we did still send them Section 7(9) notices, which the pub protector was talking about, because you still want to tell them that at this stage, there is evidence that implicates you. So you haven't arrived at any conclusions, but you're telling them that at the way things are going, you're likely to be found guilty, and please give me information so that I can have a balanced picture. Some choose not to respond to the Section 7(9) notice, and then they come back and say, you did not interview me. But that's the time when they can give you a written report and also ask me to interview. But I want to say to you that where people are being accused of serious wrongdoing, your standard operating protocol might not say they should be interviewed. I suggest you should interview people. It's just fair that if somebody is accused of something that could impact on their lives, on their career, and on the world as they know it, they should be interviewed. And of course, you would say, why didn't you do this when it comes to state capture? Before you accuse me, many of them played hide and seek, and then they came back later to complain that they were not interviewed. And the question that some people have asked is, how much time do you give people to respond? That's the difficult one. Every standard operating protocol might differ from another, but you have to look at how normal court processes go. I honestly think 10 working days is fair. But people will come back and say to you they need 2 months to give you a response. The fact is, you're not asking them to manufacture information. You're asking them to give you information they already have. They did. If, for example, it's maladministration, they acted. So they know what the answer is, why they did what they did, and what did they do. But just lastly, even if you haven't asked this, as ombudsman officers, work with them as part of the aftercare. I said it's a 5-stage process. The aftercare should not just involve sending them letters to say, do the right thing. It should also involve having meetings with them. That's what I used to do. Having meetings with them so that you can explain yourself, and secondly, get them to fix the system. In most instances, it really helped to request a meeting with them to discuss the report and to fix the problem. Sometimes even if you have the meeting after issuing the provisional report or the Section 7(9) notice, it works. If you look at the report again, they called it justice. The original report, the provisional report, was they call it justice. So it was accusing them that they're doing something unjust. They're firing a whistleblower and they call it justice. After we had a meeting with a senior delegation from the institution concerned, they considered that they are not unjust people and they didn't ill-treat the complainant intentionally. They were just missing links in the information they had when they made the decisions. And by the time we issued the report, they had considered that there were steps that were done wrongly, and they wouldn't want to punish a person for being honest. And they already have agreed not only to reinstate the person, but to give her more than what we were asking for in the provisional report. And therefore the report at the end of the day changed from they call it justice to they called it justice, which is basically they were unjust, but now they are reformed. Thank you.
Thank you so much, Professor. You have addressed most of the issues and concerns, and thank you for the examples you've made so that people can relate to. We also have Ombudsman Madonsela from Botswana, who has joined us, and I hope he has also benefited from this interaction. So I think the next on the program is for us to close. Next in the program, I think it's the closing remarks by the host ombudsman, which is the Public Protector South Africa, which is me. So I think the participants were also required to articulate specific commitments gained from the training, which will be sent to the organizers, Frankie and Marion, by email. So in closing, I would like to take this opportunity to thank Professor Madonsela. Your presentation was very much enlightening. And as I indicated as well, that one has benefited so much from your presentation. It's very helpful and it's very interesting to sit and listen, you know, and gain expertise or sharpen one's understanding of what one needs to do or how to guide the team which is investigating. So I think what we have learned for today, though we will receive the presentation, and as I indicated, for now, Frankie will share the presentation which was prepared by the center, which is using most of the information the professor has spoken about, but also what is currently happening in Public Protector South Africa, issues of quality assurance, issues of Section 79, issues of what also Prof spoke about, the clear, how the report should be clear, precise, and professional. So what we have heard from you in summary is that a good report, you spoke about you need to communicate clearly what was investigated, how, and what was the problem you needed to resolve. And you were also very specific that when drafting the report, that report should be communicating your findings to the world, and you need to know that everyone should be accommodated in the report. You also indicated that a good report is should be very rigorous, prompt, and ethical. You gave everyone an opportunity. You can go to our Public Protector website. You will get the Petro SA report, if I'm not mistaken, but also you can go and read the Mail and Guardian judgment of the Supreme Court of Appeal, where the Mail and Guardian took the Public Protector to court. That's where the professor was talking about how the investigation should be conducted with open mind, fact-finding mission. So you'll get a lot of information from there. So you spoke about 5 stages of investigation. So the complaint which is lodged, or an own initiative investigation through the media, that's what you said. And you spoke about triaging or planning of your investigation. And also during those initial stages, you can decide to refer the matter to the relevant institution which can deal with the matter properly and promptly, because in South Africa, if we are picking up that there is a crime committed, immediately refer to the NPA or to the Hawks, which is the DPCI, or as well if it's the Health Ombudsman, which is ideal to investigate, or the Tax Ombudsman, or even the Police Ombudsman. I think that's what we should be doing to avoid the delay and the workload. And then also draft an investigation plan. That investigation plan will help you to be focused also and to be detailed in your investigations and the sources you've used, the people you are going to interview, and you draft your report, and you also give the other party an opportunity, involve them as much as possible so that they don't come back and take you on review. And you said report is storytelling, and how when you write your report, you should reach those people cognitively, to their emotions, the issues of immorality, and the interesting part which you spoke about is those truths. I mean, when you attended the training, there is a truth of the complainant, which most of the time they would want you to find in their favor. There is a truth of the department where they will also tell you what is their truth as far as they believe. But what I like, you said, go and find then the real truth. I think it links directly to what the Mail and Guardian judgment said. So the report must be clear, concise, persuasive, professional. You spoke about when you investigate, you check what happened, what should have happened, the discrepancy, and it's very critical also to say if there is a discrepancy, is it reasonable, justifiable? I'm just trying to summarize for everyone who joined late the legal framework. So do not confuse information with evidence. That's also very critical, Professor. I think in South Africa, we also have that challenge that when there is information going around and then people think it's gospel truth, or then they believe it. But then as an investigator, you can't just take that and write it in your report. You need to investigate, you need to go deeper and investigate that. So you spoke about the Ombudsman institutions deal with the ethical conduct and justice. It's not more of an issue of being a court of law, but what is just and equitable. I think that's what you said the Constitutional Court mostly focus on. And also we need to show what prejudice the community has suffered, and as well what corruption is doing, what service failures is doing. And also what is critical is forensic investigations on conduct failure, especially when there's corruption. But you know, ombudsman offices are not well resourced or well capacitated. But what you said is make sure that on those investigations, you then get all those documents. Yes, we need to also use cooperate with other institutions which have those expertise. So thank you so much, Prof, for giving us this opportunity. We are better off now, and we will share all the documents. With your busy schedule, I hope you'll assist us with the presentation. So in closing, thank you so much to Professor MacArthur and the institution. I've already thanked UKZN, Frankie, Marion, Shakila. Thank you so much. Thank you to everyone. I think I can safely close this webinar. You know, COVID-19 has helped us to do things differently. And now Professor is speaking to us, taking her time. Instead of flying from Cape Town to Durban, she's sitting in the comfort of her office or her home addressing us. I think let's take these positive issues which we gain from COVID-19, use it positively. But then let's all be safe. Health protocols, let's do that. Coronavirus is real, and let's make sure that we stay safe. Thank you